In case you missed it, the truth behind Ynw Melly'S bond release date has finally come to light, and it's raising serious concerns. Initially, it was announced that Melly was granted bond on just one of the 6 charges he faces. Remarkably, he has been behind bars for 2,295 days, without bond or a guilty verdict, even after a previous mistrial. Courtroom documents later revealed he was given a $500,000 bond, sparking reactions both in and outside the courtroom. His mother even spoke publicly, expressing hope and optimism following the news.
We just still praying. I know I said I would I'll keep everybody updated with what's happening. I know right now we're waiting. So basically the judge is going to do, I guess, a written order. So we're just waiting, and that order can come any minute, or it can come tomorrow. I don't know. So we're just waiting. We're just waiting. So everybody just keep praying, keep having faith. Oh, Tessa, I've been crying too. It's been a long time coming, you know.
His single bond was approved as part of his overall bond package, leading to a significant moment when he was seen walking into the courtroom. There, the judge formally informed him of the decision.
Good morning, this is on State of Florida versus Jamel Demons. Present is Mr. Demons. Mr. Demons, can you hear us?
According to court documents, Ynw Melly'S legal team proposed an unspecified bond to be covered by his record label, $100 Entertainment. If granted, they assured the judge Melly would remain on house arrest, wear an ankle monitor, and hire 24/7 private security to monitor him closely. The proposal was so convincing that one rapper even posted that "Boy Melly's coming home." I can feel it. As the judge prepared to make a final decision, they turned to the prosecutors to hear their argument. That's when things took a disturbing turn. Prosecutors submitted new paperwork requesting that Melly be tried alongside his co-defendant, Ynw Bortlin, in the next trial. The reason it involved alarming claims connected to Melly's ex-girlfriend Mariah Hamilton and raised serious concerns about the case's direction.
Here, and you can try them together. It is to the benefit of the state to try them together, just more efficient. You don't have to do things again and again. Do it all at once, and also you get a better chance of having them incriminate each other during the trial. It benefits the defense to sever it. That way they can point the finger at each other and get away with it. So this is what's going on. But I don't think it should be automatically severed because the state is seeking penalty for Melly, because it's only the penalty phase of the trial that would be different, not the guilt phase. The guilt phase is the same. They're both capital crimes. They're seeking the penalty on one, not the other. But that goes into the second part of the trial, the penalty phase, only if Melly is found guilty.
It's simple logics. If Ynw Bortlin knows he didn't commit the crime, he's not likely to sit back and accept a life sentence without a fight. That makes it highly probable he could turn on Ynw Melly and point the finger at him. But here's the real reason prosecutors want them tried together. It all goes back to a key move made by Melly's legal team during the original trial. What most people don't realize is that Melly's lawyers had already attempted to shift the blame entirely onto Bortlin, setting the stage for serious tension between the two co-defendants.
Were his lives. Cortland Henry shows up at Memorial Hospital, Miramar. You don't see him sitting there, but where you will see him sitting is in the driver's seat of a car with two bodies, car riddled with bullets. And when he shows up with a change of clothing, change of shirt, powder residue on his hands, evidencing that he had discharged a firearm. And he lies. He lies about where the incident occurred. He lies about how it occurred. And he lies about not having the phone. I think it was Miss Bradley herself who said, everybody has a phone in his pocket, not Portland Henry.
Ynw Melly's own lawyer revealed that it was actually Ynw Bortlen who had been lying to federal investigators. According to the defense, Bortlen had gunpowder residue on his hands, a clear indication of firearm use. To strengthen their claim, Melly's legal team even brought in a forensic expert who had examined the details of the case and testified about the significance of the residue, providing deeper insight into the evidence surrounding the tragic incident.
So the right hand of Portland Henry contained 0 particles characteristic of hot residue and two component particles. And the left hand contained 1 particle characteristic of hot residue and 1 two-component particle.
Okay. And can you explain to us what that means?
Basically, overall, there was hot residue present on the hands.
Ynw Bortlen wasn't happy about being blamed, and that's likely why he's remained silent on all social media platforms since Melly's original trial. Interestingly, on the very same day Melly's mistrial was declared, Bortlen posted a cryptic message on Twitter, "Mind games don't work on people like me," followed by a handshake emoji, almost as if he was signaling acceptance of a deal. It's highly likely his legal team advised him to stay quiet until Melly is officially sentenced. Prosecutors appear to be strategizing around this, aiming to have both Mariah Hamilton and Bortlen testify against Melly. In fact, Mariah Hamilton was recently arrested for skipping Melly's initial trial, further fueling speculation that she may now be pressured to cooperate with the prosecution.
Mariah Hamilton is spending her first day at the Broward County Jail. She has no arrest record until now. U.S. Border Patrol agents arrested her at Miami International Airport Monday after she arrived on an international flight. Court records show Hamilton was ordered to testify in Demon's first trial in 2023.
Mariah Hamilton was ultimately able to secure a deal with the judge that led to her release from jail. Shortly after, she posted on Facebook, "To my village, thank you. I love you all so much. God's plan, not mine." According to reports, the judge told her, "If you agree to testify against Melly, you're free to go." She accepted the deal without hesitation. This development spells serious trouble for Ynw Melly. Investigators reportedly uncovered alarming evidence in Mariah's iCloud account, suggesting that Melly may have pressured her not to testify, a move considered witness tampering. The most chilling part: witness tampering alone carries the potential for a life sentence, even if Melly is ultimately found not guilty of the murders of Sack Chaser and Juvie.
The state filing 6 new charges against Demons and 2 others who were allegedly involved. The charges include tampering with a witness, directing the activities of a criminal, solicitation or conspiracy to commit tampering, and unlawful use of a two-way communication device. Now, a couple of those charges actually carry a life in prison sentence if there's a conviction.
The witness tampering case is separate from Ynw Melly's current trial. However, due to his alleged tampering through jail phone calls, federal authorities have prohibited him from using a phone for almost a year. The situation escalated to the point where Melly's mother gave an interview publicly exposing the county jail for denying him phone access and even preventing him from viewing his own mail.
Son has not been convicted of anything, and even other inmates that have been convicted or anything, they have the right to use a telephone. They have a right to just to be allowed to write letters to their loved ones, to receive their mail. They hold his mail, they don't give it to him.
If the evidence is true that Ynw Melly used jail phones for witness tampering, it explains why the authorities have restricted his phone access. The concerning part is that the feds likely have solid evidence to support the witness tampering claims, because if they didn't, and they illegally prevented him from using the phones, it could result in a costly lawsuit. However, during this time, Melly's lawyers seized the opportunity to defend him in court, explaining to the judge why he should be granted release. They began by highlighting his mother's interview, where she described the inhumane treatment Melly was enduring in jail, arguing that it violated his rights.
You saw Melly's statement, just saying how he's been hurt, how he's scared for his life. As a mother, how did that make you feel?
It's heartbreaking. It made me feel completely helpless. Broward Sheriff's Office definitely needs to be investigated. I mean, they are making up their own rules. We tried to go to court about this situation. The judge really doesn't have any jurisdiction when it comes to the jail, because we actually had a hearing about the mistreatment of him, and the jail they make their own rules. And I don't think that's fair, because I know that they need to answer to someone too.
They then presented evidence from the original trial to demonstrate to the feds that Melly wasn't present when the crime took place. GPS data showed that Melly had exited the Jeep they were driving, sprinted down a street, and hidden in a bush, providing a strong indication that he was not involved in the crime at that moment.
That would be the part of me saying that someone just shut the car up and was trying to shoot them. So I asked him if he was okay, where he was, and he's like, there's a car coming behind him, like hiding. He was like, there's some, yeah, there's some, I think they're still out here or something. So I'm like, are you okay? He's like, I'm okay. I said, well, where are Zach and Juby? And he said, I don't know if they're in the car. I think they're...
To further support the claim that it was a drive-by, Melly's lawyers presented evidence from the original trial, which confirmed that no firearm was ever recovered. They presented this critical evidence to the new judge, highlighting its importance in challenging the prosecution's case.
So the first thing is I didn't have a firearm, so I can't know which firearm I'm going to use in order to replicate any of my tests. So I can't make tests for this determination because I don't know what to use.
Okay.
If it was indeed a drive-by, that would explain why the firearm was never recovered, as the guilty party would have driven away with it. In response, the prosecutors presented their arguments for why Melly should remain in jail. Now, after hearing about the evidence, including a text message sent by Melly hours after the crime, in which he admitted to it, what do you think? Which side has the stronger case? Let me know your thoughts in the comments.